Hello everyone. So my topic is primary and secondary evidence. Before knowing the primary and secondary evidence, it is important to know what is evidence. So the term evidence has been derived from the Latin word evidere, which means to show clearly or to make certain, plain, ascertain, or prove. Evidence plays a very significant role in court proceeding. In layman terms, the word evidence can be defined as a set of facts or information substantiating the arguments or proposition put forth by the parties. Now, what are the types of evidences? Evidence can be broadly classified evidence into two categories: oral evidence and documentary evidence. As per the language of Section 3 of the Act, evidence means and includes all statement which the court permits or requires to be made before it by witness in relation to the matters of fact under inquiry. Such statements are called oral evidence, and all documents including electronic records produced for the inspection of the court, such documents are called documentary evidence. From the word itself, we can understand that oral evidence are any words spoken by a member or a person whose word is admissible in the court of law, which does not need to be corroborated by the documentary evidence, whereas documentary evidence are the evidences which are in document in nature or any electronic records. Moving forward, secondary and primary evidences are parts of the documentary evidence. So primary evidence is considered the best quality of evidence and is referred to as the document produced before the court of law for inspection. Section 62 of the Indian Evidence Act 1872 explains primary evidence by stating that when a document is in various parts, each part of the document forms a part of the primary evidence. But if the document are merely copies of a common original work, then they cannot be considered as the primary evidence of the original work. For illustration, we can take any original art which includes painting, drawing, plans, blueprint, etc. are primary evidences. The original form of any work, any document is the primary evidence. Moving forward to secondary evidence. Secondary evidence, as its name suggests, is the evidence that is used in the absence of any primary evidence and is defined under Section 63 of the Act. As per Section 63 of the Act, secondary evidence means and include certified copies under the provisions of Section 76 of the Act, copies of the original while ensuring accuracy in such copying, which is to say that a copy which has been transcribed from the original is considered a secondary evidence and is admissible in the court of law. For illustration, we can take a photograph of an original is admissible as secondary evidence of its content even when the two have not been compared. There are many provisions relating to secondary and primary evidences in the Indian Evidence Act. Circumstances where secondary evidence related to the document are admissible. According to Section 65, there are 7 grounds under which secondary evidence related to documents are admissible in the court of law. Some of the cases can be where the possession of original document is under the person whom the said document is sought to be proved, a person who is not reachable. Another case could be a case where a person against whom the said document was to be proved admits in writing the existence, condition or contents of the original. Another case could be where the original document is of such nature that the evidence itself permits certified copies of the same. So these are the grounds under Section 65 of the Indian Evidence Act where secondary evidences are admissible in the court of law. Moving forward to the circumstances where secondary evidence can be tendered without rendering any notice for its production. It is given under Section 66 of the Indian Evidence Act. Under Section 66, the conditions are prescribed where secondary evidence can be rendered to the court of law without serving any notice. Some of the conditions are when the document which is to be proved is itself a notice, when from the subject matter of the case the opposing party must realize that he will be expected to produce it, when it appears or is demonstrated that the opposing party has acquired possession of the original document by fraud or force. Now, coming to some differences between the primary and secondary evidence, as we know that primary evidence is described under section 62, whereas secondary evidence is mentioned in section 63. Primary evidence has more and holds more evidentiary value than the secondary evidence. Secondary evidence, being the secondary, holds the less evidentiary value. Birth certificate issued by the MCD is the primary evidence, whereas for a secondary evidence we can take that in case of a loss of birth certificate, our 10th mark sheet which mentions our date of birth can be used in secondary evidence. Primary evidence is considered to be the best or finest quality of evidence in court of law, whereas secondary evidence is considered as a lower quality of evidence. There are several judicial pronouncements in which the difference between the primary and secondary evidences are given, the circumstances where secondary evidences are admissible, how the secondary evidence can be admissible are given through the various judgments of the Supreme Court and the High Court. One of the case is J. Yashoda versus Srimati K. Shobha Rani. So, while concluding the topic, I'd like to say that primary evidence is a high form of evidence in law, whereas secondary evidence is considered to be the substitute of primary evidence. But each of these fall under the definition of evidence under Section 3 of the Act. It has also been established by way of various judgments that the presentation of primary evidence is the general rule and the presentation of secondary evidence in a court of law is an exception.